And now it's time for our keynote. So it gives me great pleasure to introduce Lizzie O'Shea. Lizzie is a lawyer, broadcaster, and writer. She is a founder and board member of Digital Rights Watch, which advocates for human rights online. Lizzie also sits on the board of the National Justice Project, Blueprint for Free Speech, and the Alliance for Gambling Reform. Lizzie's work has seen her receive the Davis Projects for Peace Prize, and she's also been named a human rights hero by Access Now. Please welcome Lizzie.
Great. Can you all hear me? Wonderful. It is a genuine honour for me to be here, I have to say. I'm so grateful to be asked and to be standing in front of the open source community. I'm a big admirer of the work that you do. I've also written a book which talks about history and politics and technology, and I've got a chapter where I talk about the importance of open source. But I just wanted to also acknowledge the conference organisers, because this has been a wonderful experience. It's been very well organised. I'm extremely impressed with how it's been put together, and I think they deserve acknowledgement. So the many hundreds of hours of volunteer time is incredibly valuable, and I think we all owe them a debt of gratitude. So I wanted to start by saying that I think as an activist and as a lawyer who advocates for digital rights, that I see the open source community really as a set of natural allies for us. We're all committed to transparency and accountability in writing of both code and law, and we're all committed to an egalitarian and respectful relationship between users and developers of technology. And I think the open source community can be an immense source of strength when working in partnership with digital rights activists, and the reverse is also true. And perhaps more than that, I actually think we can't win any of these arguments unless we work and collaborate together. So the short version of my talk, for anyone interested, is that the Access and Assistance Bill, now Act, is a disaster of both policy and also democratic process. And it's going to have very far-reaching implications, I think, not just here in Australia, but around the world. So if that's all you need to hear, that's fine. I'm now going to go into quite a bit more detail as to why I think that's the case, but that's, I think, the key takeaway. And I think it's really important that we work out how such a law came into being and what we can do to build power to make sure that something like this doesn't happen again, and that we might be able to reverse some of these attacks on our civil and digital liberties. And that means, I think, that we need to make sure we do everything we can to help those realise, those who made a mistake, realise what they've done, pay the price politically for it, and put them to work at clawing back our digital and civil rights. And these are civil and digital rights that very much would have been protected had lawmakers listened to those who are experts in the field and also the public. So of course it's easy to identify lawmakers as the key people who made these mistakes, but I also think it's not just enough to think about them alone. It's not enough to be correct about policy positions. It's very important to also be effective. And we need to think about how power works in politics, about how we can shift the mindset of politicians, perhaps not by looking to Canberra, but by building our communities and our movements outside of those spaces that can hold those lawmakers accountable. So what I'm going to use the time to talk about is some of the background and the context to how this Act came to be tabled in our Parliament, some of the content of the Act itself, and then why I think in practice it's going to be quite disastrous, the process of how it got passed, which is the eponymous sausage-making factory of Canberra, and then some reflections on it all and some discussion about what we might be able to do to correct the situation and make sure it doesn't happen again. So I'll start by saying that the AA Act, while it's very problematic, is not unprecedented. It didn't come out of nowhere. Since 2001, Australia has passed 82 anti-terror laws, all of which grant considerable powers to a bunch of different Commonwealth agencies, including people like ASIO, as well as federal police, as well as local state-based police agencies as well. The one that comes in for special mention, of course, is the data retention regime, which you can see there was passed in 2015. And this, I think, is a particularly troubling law for this for technologists around the world, because it requires companies to hold metadata about their clients for up to 2 years, to be accessed by a long list of agencies without a warrant. So no requirement to check whether this is an appropriate use of power. And we've seen an expanding use of these kinds of rules, despite being told that they would be very limited in their effect when the laws were debated. It is actually the reason why Digital Rights Watch came into being. We watched how we fought against the metadata retention regime, and we ultimately lost. It was passed into law, and we wanted to start building our ranks so that we can stop these things happening, we can try and limit their worst excesses, and we can try and create a culture of rights-respecting politicians who make good tech policy. So that's where Digital Rights Watch came into being, noting that there was an absence of a digital rights advocacy organisation. Of course, there are others like EFA and many other organisations, but we thought this was an opportunity to build an organisation, which is what we've done. So it's also not unprecedented in the sense that the UK has a very similar law. Now, I'll explain why it's nowhere near as bad as the AA Act, but the Snoopers Charter did come into force. It allows people to, agencies to review browsing history. It does allow some powers that are similar to the Australian law with limits. Now, this is not an accident. So the United Kingdom and Australia are both part of the Five Eyes Intelligence Alliance. Now, if you don't know what that is, the Five Eyes is the Anglophone countries, so the United Kingdom, Australia, the United States, New Zealand and Canada. And that's a long-term intelligence sharing alliance who cooperate on all sorts of things. So since the Snowden revelations, of course, we've seen a lot of encryption adopted as standard in mainstream services. And this is a problem for law enforcement, of course, because it means they can't access people's communications as easily, which for privacy advocates is a good thing, of course. But what it meant was that they see this as a phenomenon, as I'm sure you all know, of going dark. So it limits their capacity to conduct surveillance, and they're trying to do something about it. So the Snoopers Charter was really the first foray into that space. And then we know that the Five Eyes had been talking for some time about focusing on attacking encryption specifically and using Australia as a place to do that. The Five Eyes turned their attention to Australia because we're the only Western democracy without a Bill of Rights, which I think is an astonishing fact. We do not, that puts us in a category we don't want to be in for a bunch of reasons. It means our law doesn't have the capacity to consider rights in a way that it ought. It means that we become quite distinct from similar jurisdictions around the world because of it. And it means also that we become the place in which lawmakers can experiment with egregious laws without having to worry about the consequences from a rights perspective. So what happens is the Five Eyes get together, people like Peter Dutton and his equivalent, they talk about how to make policy and where to do it. And for digital rights activists, I think it came as no surprise that Australia would be the place in which some of the serious attempts to break encryption would happen for the reason that I just mentioned. So we get to 2017, where Malcolm Turnbull, a supposedly very intellectual Prime Minister, talks about the war on maths. Now, the discussions were happening in 2017. We knew, of course, that this would be the place where they wanted to experiment. We didn't know what the bill would look like at this stage. And so that's when the politicians start talking about terrorists, criminal hackers and pedophiles, which is the great unholy trinity of authoritarian governments. I think they're like the three horsemen of the authoritarian apocalypse. You know, when you hear those terms, that your rights are going to be violated. So that's when these politicians started talking about this. And of course, it's not quite clear to me whether Turnbull actually believed what he said about the laws of maths not applying in Australia, but it also occurs to me that it doesn't really matter. What we can see here on display is the poverty of our political class. They are not prepared to stand up to the national security establishment when they ask for powers. They're not prepared to even ask why they might need those powers. And they're not even bothered by the technical realities of the requests that are being made. So I think what we see in this claim is not really that the law of maths doesn't apply in Australia, but more that the laws of logic don't really apply in politics. Politics is about power. It's not about good policy or technical realities or logic. So in the lead up to this bill, we're therefore, as digital rights activists and probably many of you as observers of this space, sitting there waiting for legislation or a bill to drop because we know it's coming and we know that they're preparing for it. But of course, it's all done behind closed doors. So then we get to August 2018, which is when the first public exposure draft of the bill was made available. Now, I want to tell you at this point a little bit about the content of the bill, because it did end up being passed largely unchanged. And while it's a very complex piece of legislation that amended many different acts, I want to tell you a little bit about the most controversial aspects, because I don't expect you've all got time to read it yourself, and I've done that work for you, so you don't have to. The key part of the legislation that captured probably the most attention is a schedule that introduces some notices and requests. So what these do is they allow certain agencies to provide these to technology companies and others to do acts or things. And all of these, none of these steps require the approval of the judge, I should say. So the steps are there, the agency, and each of these components have many things attached to them, I should say. So the agency can be anyone from the Northern Territory Police right up to the Australian Security and Intelligence Service, our overseas spying arm, and everything in between. So state and federal police and law enforcement. A designated communications provider can be many of the major technology companies that you can imagine, but also when we were asking the cybersecurity minister, who that portfolio no longer exists, tellingly, but at the time, he was asked about what this meant and was told anyone who operated a website. So really anyone who's facilitating communications across the internet would be captured by this definition. And then what the agency can do is provide to the designated communications provider a request or a notice. And attached to those three things are many, many acts or things that can be required of the designated communications provider to assist the agency. Now, the distinction between them is that a technical assistance request is voluntary and the notices are both compulsory. So the assistance request can be to assist, obviously, as can the assistance notice, even though the notice is compulsory. The capability is to build something rather than just assist. But I did want to pause on that for a quick moment, because I'm actually very troubled by the voluntary one as much as the compulsory one. And I say that because, well, sorry, I should say, of course, if you refuse to comply with a notice, there's very lengthy jail terms associated with it and also considerable fines. So it's not as though it's easy to resist a notice. But one of the things that came out in the course of discussion around this legislation is that someone from the Communications Alliance, which is the industry body for the telecommunications sector, indicated that technology companies respond to 1,000 requests a day from law enforcement for data under the metadata retention regime, which I find shocking because that's a lot of information that's being shared without a warrant, without scrutiny by a judge, and without really, I think, the public being aware of how commonplace it is. So I think there's a lot of problems with a voluntary regime as well, because that way a lot of things can happen without the public having the chance to scrutinise them. Of course, while I'm also concerned about the compulsory requirement, I should say there's no reporting on these in any meaningful way. So we can't know how many requests or notices are issued. We don't even get to know whether any of them were varied or done in an emergency setting, or whether the Attorney General, who does have to approve notices, how many the Attorney General approves. None of this is transparent. It's designed to be a closed door, secretive regime to facilitate cooperation between technology companies and law enforcement. Now, I did say that I was going to talk about some of the safeguards that are in place on this, and there are a few. The most perhaps notorious is that the agency cannot request that the provider create a systemic weakness, which of course sounds good, but I probably don't need to tell you, systemic weakness is not defined in the Act in any meaningful way. So it's very telling that the key safeguard that they like to talk about is in fact something that is almost meaningless. It's very difficult to identify systemic weakness in advance, except to say that almost any of these things that you can imagine a law enforcement agency would like a company to do probably do risk creating a systemic weakness. And it's something really that you can only define in retrospect, I think. So this safeguard, I think, is almost meaningless. It's window dressing more than anything else. I'm prepared to buy a coffee or something more substantial for anyone who can come up with a good metaphor for this, because I was trying to talk about why systemic weaknesses are difficult to define in advance and to stop before they happen. And the best one that I can come up with is it's like hiding a nuclear bomb in an unlocked garage or shed, because you're not offering any protection on it. If it goes missing, then it's over. You have no control over what happens to it after that. And it's a very serious thing, a nuclear bomb, and also a systemic weakness. But if you've got a better one, please come and talk to me afterwards, because I think we do need to get better at talking about these things in real world terms. So the other issue is that there's no judicial oversight over this process. So what I mean by that is you can issue one of these requests or notices subject to a warrant or an authorisation. So you need to have an underlying warrant in some circumstances. So what that means, a judge will approve the activity that law enforcement's trying to carry out. The judge will not see the request or the notice, and so how that warrant is executed is not something that the judge gets to opine on. I'm relieved the judge at least looks at something, but I don't think that's enough. I think it's very important that agencies are put to the task of reducing to paper why they want to do a particular thing, but I often think it's not enough in this context for the judge not to see how it will be executed in the request or notice. But what I should say is, what I said before was it's not just a warrant, it's or an authorisation, and that's I think where it gets quite tricky. I did have a glorious moment actually in this nasty period in which we're advocating on this. I don't know if do you guys know who Chris Kenny is? I was going to put a picture of him up, but I thought I might get sued for defamation. But he's a notorious right-wing commentator who did sue the Chaser for defaming him by photoshopping his image on, this is uncouth, onto an image of someone having sex with a dog. So the point being, he's like a cross, I was trying to describe him, he's a cross between Andrew Bolt and, say, Alan Jones, and he's on Sky News. So I'm campaigning in this time with my fellow advocates in this brief window where we had to discuss this, and I was asked to go in and do an interview on Sky News, and of course I was very reluctant. It was 9:30, that's my evening, it's quite valuable, I don't want to spend it with people I don't like. However, I went in and Chris Kenny says to me directly, you've been talking all about how this is a warrantless regime. That's not true. I've been told that you need to have a warrant in order to use these notices, and I had the great honour of saying directly to his face on live television that he was wrong. So it makes it all worth it, in my view, giving up the evening. So I want to explain why he's wrong. So an authorisation, I want to use an example. In the metadata retention regime, you're not required to get a warrant. You're authorised to access the metadata of anyone if you're on the list of agencies without seeking the approval of a judge. So that's an authorisation. And I want to put this into practice as to what this might look like in terms of a notice, because I think it's kind of telling how bad this law is. So if an agency, for example, knew that a source was leaking information in breach of national security rules to a journalist, what that agency could do is they could seek the metadata of that source without knowing the identity of the source, and to do that, that's an authorised thing, they don't need a warrant to do that. They could go and to a technology company and ask them to install malware on a journalist's phone who's communicating with that source, and a judge would never have seen any of that. Which I think is deeply troubling. It's also troubling because one of the few concessions we got in the debate about the metadata retention bill was that there would be a journalist's warrant that was designed to protect exactly against the government seeking the metadata of journalists for this purpose. And essentially that's now been rendered moot, that's circumvented by the capacity to issue these requests or notices, which I think is deeply troubling. So once you have a program that allows warrantless capabilities, it infects other forms of legislation when other powers are increased upon what already exists, and it's deeply problematic. We really need to stop this at its source before it happens. So the other quick thing I wanted to mention is that there's also a bunch of computer access warrants that facilitate government hacking. They are at least somewhat better in that there's a warrant process, but they're also deeply troubling because I think government hacking is a big problem for our democracy, for also our digital security. And that's the other kind of very controversial aspect of the bill, but the part that received the most attention is the requests and notices that I just mentioned. So I want to give a little bit of context as to what this looks like in relative terms. I talked about the Snoopers Charter before in the United Kingdom, but I should say this law wouldn't pass muster in somewhere like the United Kingdom, which has rights protections built in domestically into their law. The United Kingdom, at least for now, is also subject to EU rights protections. It wouldn't pass muster in the United States, where they have a First Amendment protection, which prohibits, of course, limitations on speech, but also prohibits forced speech, so the requirement to write code or disclose code, which I think is an interesting idea. It doesn't exist in Australia. So in that sense, this is, I think, very egregious and a world first in terms of the capabilities that it bestows upon our agencies. And the critical absence of a lack of judicial scrutiny, I think, also sets us apart. Now, I would like to take the opportunity, of course, to note that I do think law enforcement need powers to be able to do their job. I'm not naive about that, but I also think it's very critical that we think carefully about what we put at risk when we extend extensive powers to those agencies. It's not as though this is always going to be an extremely targeted set of tools or capabilities created by this law. It's going to affect all of us. And that should give pause, rather than just assuming that everything that is asked for by law enforcement is valid to fight even very serious crimes. And I'm a lawyer, right, so I understand that there are limits on systems. For example, I have the privilege over communications with my client. If I was a criminal lawyer, I would go into court and I would be able to say to my client that they have a right to a privilege against self-incrimination, that they don't have to give evidence against, in a case against them, that they also have a right to be presumed innocent until found guilty. These are limits on our legal system that undoubtedly mean that some people will get off. There's no doubt about it, but we think they're important protections against unsafe outcomes in our systems. And that is the balancing act, that just when people need powers to do something from law enforcement doesn't mean we should necessarily grant them, that we have to change the calculus of how we understand these things, and also appreciate that there's a public interest at stake, there's the integrity of our digital systems and our judicial system in my example, and that's the way to think about it. So I want to just talk a little bit now about what this law might look like in practice, and the example I want to use is the WannaCry ransomware attack. Now, I'm sure there's many of you in the room that know more about this than me, but I want to walk through it so that anyone who doesn't can perhaps have an insight into what this might look like in practice. So I'm sure you all realise that the WannaCry ransomware attack compromised thousands of computers around the world. It operated by exploiting a vulnerability within Microsoft software that allowed the attackers to prevent people accessing their files unless they paid a ransom. It was eventually revealed to be small-time criminals using this exploit opportunistically to make money, but there is, of course, a broader context to this particular episode in our recent past. So Microsoft claimed in a company blog post that the National Security Agency in the United States had discovered this vulnerability well in advance. However, instead of disclosing the vulnerability to Microsoft so they could patch it and protect their users, the NSA kept it to themselves. So the NSA, in essence, was holding on to this vulnerability to use for its own purposes. And in this way, I think this is going to be a phenomenon we see more of, where agencies hoard these vulnerabilities as a form of digital weaponry to be able to use against their enemies, with the risk, of course, that they'll also eventually be used against us. So at some point, that intelligence about that vulnerability was either stolen or went missing. We're not exactly sure, but it was entirely predictable because these vulnerabilities are a highly valuable commodity in the cyber world. And it's real people who pay the price. So the NHS was obviously compromised. People couldn't access their medical records. Ambulances were diverted. Of course, many thousands of people were put to the gross inconvenience, large and small, of not being able to access their files and all these sorts of things. But the reality is, I think this was not unexpected by many in this space who saw the potential for these things to occur, or in retrospect could see it as being highly foreseeable. And Brad Smith from Microsoft wrote a blog post at the time, and I think it's worth reading in full, that repeatedly exploits in the hands of governments have leaked into the public domain and caused widespread damage. An equivalent scenario with conventional weapons would be the US military having some of its Tomahawk missiles stolen, and this most recent attack represents a completely unintended but disconcerting link between the two most serious forms of cybersecurity threats in the world today: nation-state action and organised criminal action. The two most serious forms of cybersecurity threats in the world today. The Australian law, the AA Act, not only allows agencies to exploit similar vulnerabilities, it gives them the power to create them. So it facilitates the exact nation-state action that Microsoft claims is one of the most serious threats to our cybersecurity, and it also puts us at risk of the other, of organised criminal action, in the event that these exploits cannot be controlled and managed by our agencies. So I should say, to be fair, there is one limitation in the AA Act which talks about how an agency cannot prevent a technology company from patching a vulnerability that they know about, which also sounds good, but in this instance, it means nothing at all, because of course Microsoft didn't know about the vulnerability, the NSA did. There's no duty in our act to disclose a vulnerability to the company to be able to patch. They're not interested in cybersecurity and safety for users. They're interested in maintaining their ability to access vulnerabilities. Now, of course, the WannaCry example is slightly different because it didn't involve an agency building it, but you can see how a very similar phenomenon might well play out in circumstances where one of our agencies makes use of an exploit or also forces a company to create one for them to use. And I mean, I should say as well that we have to trust here that all these agencies are going to be able to protect and guard the capabilities that are created under this Act. And we're talking about not just ASIO or ACES, we're talking about the Northern Territory Police. And I mean, I don't mean to bag the Northern Territory, but I'm just not convinced that these guys understand what they're going to be holding on to if they request these things. And I should say as well that in subsequent discussions, I spoke with a New South Wales police officer at a think tank event in Sydney, where he talked about how he works on kind of investigations relating to things like pedophilia and others. He was, as far as I know, New South Wales police were not meaningfully consulted in the lead up to the tabling of this bill, and he was essentially telling me that they were now being encouraged to use it. So the idea that this was a response to a need by people actually dealing with these crimes on the ground seems somewhat hard to believe for me when the key people who are doing this work aren't involved in the process of creating the legislation itself. So, yeah, we'll get to that in a minute. So it gets to August 2018, and the public consultation draft is released by the Department of Home Affairs, and we're given an extremely truncated period within which to respond. We've given 2 weeks, essentially a little bit more, to provide a response to the exposure draft. And so, of course, we diligently get to work. So civil society, we drafted a lengthy submission highlighting all the faults with the bill. We worked with the Juice Media to create a wonderful video about the Ask Access Act, and an honest government advert, which you're welcome to watch. We also recruited nearly 15,000 people to make a submission through this process. It was a pro forma submission, but it, I think, is an important number to remember in a context in which we're commonly told that people don't care about their privacy, that this bill is far too technical for people to understand, that that's not true. So widespread engagement with this process. And it wasn't just us, of course. You don't need to believe just me. There was very widespread engagement. Oh, no, I'll go back to this. That's coming. There was very widespread engagement from, that gave me a shock, from industry and business. So lots of the community that you would usually expect, perhaps who aren't aligned on lots of different topics, coming together to talk about these issues. There was a large number of submissions in addition to the 15,000 that we made. And pretty much what you could discern from that process is that the only people who were interested in passing these laws, who advocated for them, were the people who were likely to gain power from them. It was not as though others saw the benefit of them to any great degree. And many, I think it's fair to say that there was an intense chorus of opposition through this process. What that we then know, of course, is that 2 weeks after that period of consultation ended, 2 weeks after that, the legislation, the bill was tabled. So essentially this guy waved it right through Cabinet, and which I think is quite ominous, without reading any of the submissions that were put by civil society and others, I think in any meaningful way. It's not possible, I think, to have read them within a 2-week period. So what we see here is a clear intention to get this onto the table in Parliament, to get this passed as quickly as possible, and to show a real contempt, I think, for engagement with the political process by people who have a stake in these issues, which is deeply disappointing. So it was immediately then referred to a committee, which is the Parliamentary Joint Committee for Intelligence and Security, which of course is a hilarious name because there's not much intelligence and not really a commitment to security on that committee. The Parliamentary Joint Committee is the body that a lot of these bills are referred to. The process is common. So the 82 bills that I talked about before, many of them will have gone through the Parliamentary Joint Committee on Intelligence and Security. So the process is designed to allow people who are experts in the field to come and talk to politicians about it, to try and explain what they think are the problems with the laws, to provide written submissions, of course, laws, to provide evidence in person, to kind of talk politicians through about why this law might be not ideal and what they could do about it. But what happens in this committee is it operates under a gentleman's agreement, really, between the two major parties, whereby they come to a compromise behind closed doors about passing this legislation, and it feels often to be quite a vacant and empty process to provide evidence to them. Doesn't mean it's not worth doing, but it is immensely frustrating when a lot of lawmaking happens by a coterie of people rather than by politicians who feel accountable to those that they're there to represent. So many people gave evidence, including me, including other people in this room, for which, I think we should all be very grateful. It was, people from business, people from the academy, cryptographers, civil society advocates like me, and a large range of submissions which I think in a very articulate way highlight all the weaknesses with this proposed law. Now, in some circumstances, this bipartisan consensus, this gentleman's agreement, might have been a valid way to make law, I suppose, if you're in a crisis, but I just don't think that's the case anymore, and I think it's deeply troubling for our democracy. The PJCAS heard all the evidence, and it's not just me that you have to believe thought this was a problem. There were many people in Australian business who found it deeply troubling, who put it to them. There's some great submissions online if you want to see some of the arguments against it that answered all the talking points put by the coalition. And the diversity of this coalition of people, diversity of the coalition of people against it, and not the political coalition, I think is quite impressive. There was also some polling done on this, so it found that 85% of Australians thought it was important or very important that the government not introduce weaknesses into encrypted systems. And essentially there's quite a strong case there that this is a very problematic piece of proposed legislation. I should say as well that digital rights activists joined forces with industry to put up a united front, which is not a common occurrence, and I'm, as a digital rights activist, I'm obviously commonly very, very critical of these companies and how they approach questions like privacy and user rights, but I think this coalition is a testament to the seriousness of this bill. And I was involved in giving evidence, as well as I directly lobbied a bunch of politicians with industry people as well to try and talk them through why I thought this was a problem and why they should not pass this legislation. So this all sounds like it's a good kind of campaign to stop it, and I must admit I was very proud of the work we did, but I was a little bit surprised when the Labor Party started to say that it wasn't necessarily going to wave these laws through. I mean, maybe that's a reflection on the Labor Party. The backbenchers started talking about it. Penny Wong started talking about it, who's a member of the committee I mentioned. Shadow Attorney General Mark Dreyfus started talking about the problems with the law. And eventually they began to say that they publicly indicated that they wouldn't file a report that was by consensus on that committee, that they were going to file a dissenting report highlighting the problems with the bill. Now, that may sound like not much, but I have to tell you that's never happened. So in the PJCAS, those 82 bills, they've all pretty much gone through without any kind of opposition. So this is the first time we've seen a crack in that bipartisan consensus on a law. And I think that is a testament to the work of lots of people who contributed to the campaign to stop it. But how long do you think that lasted? It lasted 4 days. So then the bill passed into law. And it's pretty disappointing, of course, that occurred. The Labor Party started talking about the need to compromise, the need to pass these laws before Christmas. So this is the statement from Mark Dreyfus, which I think is ridiculous proposition, because a lot of the timeframes on the powers contained within the Act wouldn't have permitted anything to be done before Christmas. But this idea took on a kind of zombie valence, and it became very difficult to argue against. Because by the time we're talking about this is sort of early mid-December. So the idea that this was going to be used before Christmas was farcical, but of course, when you say the words terrorism, it becomes very difficult to find the Labor Party doing what it's supposed to be doing, which is being in opposition. Now, of course, the Labor Party then tried to complain that they were double-crossed, that they had plans to introduce amendments and all those sorts of things, and that may be true, but I also think it's less of a betrayal and more of the Labor Party being outmanoeuvred, I think, on these questions. And part of, I suppose, what I imagine their strategy is to be a small target at that time before the general election, which came shortly thereafter, which they assumed that they had a very good chance of winning, which of course was a gross miscalculation. So what I would say is that the more you learn about how this bill actually passed, the worse it is. There was a lot of horse trading and gross stuff going on behind the scenes. And it got to the point where Bill Shorten eventually was tweeting at Liberal politicians to return to the Parliament floor, because this is the last day before the end of the parliamentary year, to pass this bill. This is in a context in which they'd acknowledged how bad it was, and their backbenchers were tweeting against it. They'd had a huge amount of evidence telling them that it was a bad law. And it's gross. I don't really want to spend much more time on it. I've written about it if you want to know more about it, but it's a really disgusting display, I think, of how our democratic process at its absolute worst, that it need not be like this, and that horse trading and playing politics between the two major parties is a really damaging phenomenon for our democracy, and we need to do something about it. Great, we're all agreed we've got to do something about it. So the bill is already also having consequences, so we know as well that it's being used. We know that it's going to have widespread implications. Notwithstanding that it's shrouded in secrecy, I'm sure many of you as an educated audience in this field will appreciate just how bad these powers are when left unchecked. And even if, I don't think we should believe any accounts from law enforcement that they'll use them correctly and appropriately and have regard to the wider question of digital security. I think we should presume the worst and use that as a basis to say that this should be reversed. So the question then is, what do we do about this? I think it's important to come to terms with how it happened, how this process was allowed to unfold, and how we can make sure that it doesn't happen again, because we're not alone in this. Our counterparts in the other Five Eyes countries will face similar battles in future, and we need to lead by example, but we also need to build alliances so that we're better able to resist these really oppressive laws. And the first thing I suppose I'd say is that it's very clear that experts and people with detailed knowledge of their field are constantly and systematically disrespected and disregarded by those in politics. Their voices are just not valued. And even on matters where it's a technical impossibility to balance the considerations that politicians say they're trying to do, it's very easy for that to just be forgotten and replaced with a soundbite and cheap rhetoric. Even people who are supposed to be our allies, I should say as well, admit that technology is peripheral to our understanding. So Claire O'Neill gave a speech at the end of last year where she talked exactly about this. She acknowledged that she was absolutely part of the problem, thanks Claire, that technology is pretty peripheral to what we talk about in Parliament. And the last quote I think is important there. We saw this with encryption and metadata, where even some of the people advocating for the legislation didn't seem to understand it properly. What I am getting at here really is that the party political system and our politicians are really failing people. They're failing to get us good policy in relation to technology. But I'm not convinced, to be honest, that getting them to better understand it is our key objective here, because it's within their grasp to do so. They think it's politically expedient, or they think they've made a calculation that there's not serious consequences in conducting themselves in this way, and it's our job to change that. So if we're going to resist these laws and future draconian laws, and we're going to make good laws in relation to technology, we need to think about not just educating politicians, but building power outside of Canberra that can hold these politicians to account, that can ensure that this kind of attitude is not allowed to continue in places like Canberra. So what does that look like? I think that means talking about technical topics in accessible ways, first and foremost. So encryption is not just about maths or cryptography, it's about the security of our digital infrastructure, our healthcare system, our energy grid, our banking system, our public transport services. They all rely on encryption to ensure that the wrong people can't get access to information as it moves through space. It's not that encryption is just a good source of protection. It's really our only protection, our last line of protection against criminal activity and state-sponsored hacking. So when we compromise it deliberately, we put all those systems at risk. We need to get the message across that everyone has a stake in defending encryption, everyone who uses the internet, which is on a regular basis to do any kind of thing, which in the digital economy is everybody. I think in framing encryption and debates about encryption in this way, we can undermine then the accepted narrative about what these laws are about. That that we can start to push back against the idea that terrorism, pedophilia, criminal hacking are so egregiously bad that we need to pull out all stops to protect ourselves from them. Law enforcement agencies have considerable power at their disposal currently to deal with these threats, and they need to get better at using them. We cannot allow them to put our digital security at risk so that they can get easier access to things that can help them do their jobs. It's not a compromise that we ought to be prepared to make. If we were to define national security, I think in this room, I think we'd include digital security for everybody as part of the idea of what it is to have a secure nation. But when it's left to intelligence agencies and law enforcement to define national security, they make it synonymous with powers for them. And that's something we have to change. Yeah, thanks for the applause. So therefore, encryption is not just it's not a barrier to law enforcement doing their job. It's also protection for us from criminal conduct and state-sponsored hacking. And in that sense, I think we also need to start talking about encryption as not just something that's for the protection of journalists and whistleblowers, that actually it's for everybody, that unions, welfare organisations, health charities, lawyers, that we all need to work together with technologists, cryptographers and coders to build a very diverse coalition that can talk about these issues rather than seeing it as a niche technological one. And I think civil society has a great role to play in that, and this kind of collaboration, talking to you guys hopefully talking to me and others who are in civil society, is a great opportunity to do it. And again, I just think it's fantastic that you guys are prepared to spend the time listening and thinking through these issues, because this is how we start to build that power. Industry certainly has a role to play, in my view, and industry has a role to play in recruiting other kinds of industry to the cause as well, because of course many different aspects of industry have a stake in making sure that we have strong encryption. I'm just going to check the time, but to make sure that I'm not taking up too much time, but I just wanted to tell one quick story, which was that I spoke to a journalist when I was in Canberra from the West Australian, who talked about how, which didn't occur to me, I must say, so I'm learning all the time, how ground zero for driverless technology in Australia is actually in the Pilbara, where mining companies make use of driverless technology and using it all the time. Now, he also pointed out to me that BHP is constantly facing hacking attempts, often by what they assume to be state-sponsored hacking. I think there's plenty of people in all parts of the world who we trade with who are very keen to know how BHP sets its price for iron ore or other things, to get inside information into how that company works. BHP is not someone I normally feel like I'm aligned with, and yet I think they've got a stake in also protecting encryption so that their systems can remain intact and resist these kinds of hacking attempts. So I think industry's got a role to play in talking to those people, because those people don't listen to me. They like to talk to their counterparts in other industries, and there's a diverse coalition that can be built there. But that's work for industry to do itself, and I think we've got a job to do our part in building a diversity of colleagues from other organisations who are unexpected, perhaps in terms of how we share our interests, but that's what makes it a very strong coalition. When I was in Canberra, I spoke to Michelle Rowland, who was the Shadow Communications Minister at the time, and she said to me, don't worry, we're not going to pass this law. And I was like, great. And then she said, but you should run a marginal seat campaign on this law for us. And I'm trying to put together why those two things go together. But I think that is advice that we should take up. If we could organise different organisations, but also lots of different people, to start communicating with their politicians to show that voting in this way has consequences for their electorate, I think we can start to build power to make sure that politicians start factoring into their thinking that they may face electoral consequences if they continue to make bad policy in relation to digital security and technology. The bottom line, I think, is that in seeking to break encryption, what's going on is the government is prioritising the interests of agencies over the citizens that they're supposed to protect. They want to stockpile these digital weapons to use against their enemies. And this is, I think, the future of warfare. We're only going to see more of this as time goes on. And we need to be the ones that resist it. You can't say that you're preparing for peace when you're building weapons and stockpiling them. And it's our job as activists to turn those weapons into ploughshares, to beat them into ploughshares, and to make it as technology topics as a force of peace building rather than preparations for war. So we weren't successful, of course, in Australia in stopping the AA Act, but we did manage for a very brief moment to break the bipartisan consensus on national security, and I think this is extremely significant. We also managed to recruit 15,000 people to make submissions on these topics, despite the fact that it's considered technical, and there's a widespread assumption that people are prepared to give away their privacy at the drop of a hat. Those things are significant wins. I would also say that we are having other successes. I don't think the successes always look like how we imagine, but for example, Peter Dutton's biometric bills, which were also about facial recognition, which were also permitted egregious invasions of privacy, were rejected by the Parliamentary Joint Committee for Intelligence and Security, which I mentioned before, which is astonishing given it's a bipartisan committee and Peter Dutton is from the government, that they would reject these bills on the basis that they had insufficient privacy safeguards. I think that's a consequence of people getting active on these issues and appreciating that these kinds of approaches to lawmaking can no longer go on. I think it would be very easy for them to wave through these things, and we need to keep building our opposition to these laws so that they can't continue to consider these processes without scrutiny or without consequence. Of course, there are downsides as well. We've certainly seen several raids on journalists that have occurred since the passage of the AABill, including relying on provisions within that were imported into legislation by the AABill as well. So I'm not trying to make out like we're successful in this way. We've got very serious consequences that we have to deal with. But I think there is a way in which we can start to see how these things can turn around, that we can start to change that calculus in the mind of lawmakers and make them feel as though they may pay a price if they continue to support legislation that violates privacy and digital security. I suppose I ought to probably admit that the Labor Party has tabled a bunch of amendments to the legislation itself, to the AA Act, which were in line with the amendments that they said that they were betrayed by the coalition on. I'm not convinced that they're going to get up, but it would be nice to see that passed in the event that the government did change hands. So there is movement and they feel accountable enough to have had to do that. But we need to keep pushing and keep organising because this war is going to continue. One of the things I like to go back to is look back in history for people who faced similar battles and to see how they approached it. And one of my favourite people from history is a woman called Rosa Luxemburg, who was involved in the German Revolution actually in the early 20th century. And why I like her is she talks a lot about defeats and how you approach defeats in political terms. And she said, her argument is, where would we be without those defeats? This is what she wrote, from which we draw historical experience, understanding, power and idealism. She says, we can't do without them because each one contributes to our strength and understanding. I think that's what we should take from this process. We need to contribute to our strength and understanding and make sure we can use these lessons to build a stronger movement for next time. So what you can do, I think, is to get involved. So Digital Rights Watch has a program called Digital Rights Defenders for people from the technology sector to get involved in all kinds of ways. That might take the form of helping us write submissions, helping us activate groups of people who can call politicians in marginal seats. It might also be providing technical expertise. It might also be giving money if you don't want to be involved in these things. I think Lindsay might have mentioned in a talk earlier, we only have 1.4 paid activists who work on digital rights issues, which is an astonishing reality of how small our civil society is. So we need to build our ranks, and we're looking to you to help us to do that work. I'm not a coder, I'm not a developer, I'm not a technologist, I'm a lawyer, but I love working with people who are interested in these issues from a technological background because I always learn a lot. I always get told when I've made a mistake, which I don't mind. And it's the way in which we can be more powerful to build the consensus in all different ways that these laws can't continue, that this approach to lawmaking and technology policy making should not be allowed to continue. So I would encourage you to get involved in any one of our activities, to talk to your employer about what they might be doing as well if you're from the tech industry, and find ways that we can contribute to our strength and understanding of these laws so that we can make sure that next time we face a battle like this, we can win, and we can even start to claw back some of what we've lost and build a society that is based on respect for rights and good technology policy. Thank you.